Welcome all of you. My name is Colleen Lindgren. I'm the Legal Programs Manager at the Goldwater Institute, and I have the privilege of working with all of you as members of our pro bono program, the American Freedom Network, and thank you for taking the time to join us today. I hope you find this helpful and informative. We're going to be reviewing some state-based litigation in response to COVID-related issues and regulations, featuring cases in Arizona, Kansas, Mississippi, and Wisconsin. You should have received CLE materials to use for your records and even just as a reference during this call. If you didn't receive that, please just shoot me an email. I'm happy to send them your way. And we will take questions at the end of the entire presentation. So please save your questions for that time. And you should have received instructions when you called in saying that if you press 6, you can request to speak. So at the very end, if you have a question, I'll announce when we're going to take questions. You can press 6 and we'll let people in order of when they request. So we'll start off today. I'm just going to do a brief introduction for our speakers. And we have Rick Essenberg, who's the founder and president and general counsel of the Wisconsin Institute for Law and Liberty. We have Aaron Rice, who's at the Mississippi Justice Institute and serves as their litigation director. We have Sam McRoberts, who's general counsel and litigation director at the Kansas Justice Institute. Tim Sandifer, who's the vice president for litigation at the Goldwater Institute. And Howard Dworman and Mark Victor with Attorneys for Freedom Law Firm, and they are also members of our American Freedom Network pro bono program, and they have recently taken on a case in Arizona that I think everyone will find interesting. So looks like Rick is still having a few issues calling in, and so Aaron, if you wouldn't mind kicking us off, that would be great.
Yeah, perfect. Well, hey everyone, my name is Aaron Rice. I'm the director of the Mississippi Justice Institute. We're a nonprofit public interest law firm located, surprisingly, in Mississippi, as the name implies. And I'm happy to be here today, get a chance to talk to the folks in the American Freedom Network, and thanks Colleen and Goldwater Institute for setting this up. So I'm just going to discuss 2 cases that MJI has had an opportunity to litigate here during the COVID-19 pandemic. The first one is about a drive-in church situation, which I think seems to be kind of a common theme that many states have dealt with. And I think that from the agenda, it looks like Rick has had a case like this in Wisconsin, and Sam in Kansas may have had one like this too, I think. But so in Mississippi, we had a statewide shelter-in-place order like most states did. That order did not directly address church services. It did include churches as essential businesses. So in other words, they were allowed to remain open. And, you know, there was some informal guidance that recommended against in-person church services, but that was about the extent of it. So the state of Mississippi was trying to basically, you know, have some handle churches very delicately and not instruct churches what to do during the pandemic. So our client in this case was King James Bible Baptist Church up in Greenville, Mississippi, and they and many other churches in the area began having drive-in church services. And so just to describe what that means, I'm sure most of you are familiar, but in this context especially, the King James Bible Baptist Church was a small church. You know, they had several elderly members who really didn't know how to use their social media accounts, if they had any, to live stream the church or anything like that. And so it was just a few cars pulling into the parking lot. They were parking 6 feet away from each other, not getting out of the car, keeping their windows rolled up, you know, following the CDC guidelines, all of that. And they would, you know, some churches would use a shortwave radio transmitter for the pastor to preach to the congregants through their radio. Our client, the pastor, had a very loud voice, and he just preached very loudly, and they could hear him through the car windows. And so a mayor in Greenville named Mayor Eric Simmons decided that this was not a good thing for whatever reason I can't imagine, and so passed an executive order specifically banning drive-in church services, despite the fact, like I said earlier, that clients like ours were doing this in a very safe way. And so after that order was passed, the police came to our client's church, threatened all the members with citations if they continued the service. They did have the service. This was a Thursday, Easter Monday service. And they did actually, the police went to a different church and actually did issue fines. We never really understood why the police did not issue fines to our clients. They didn't go through with it, but they did threaten them with fines. And then our clients were not really sure if they were going to be able to continue to hold their church services. And so the Mississippi Justice Institute, we partnered with another great outfit called First Liberty Institute. We filed a lawsuit on behalf of King James Bible Baptist Church, the church that was threatened with the fines. Another group, Alliance Defending Freedom, came in and filed a lawsuit for the other church that actually did receive fines. And, as you can imagine, both of our lawsuits were based on, the free exercise of religion and in the First Amendment, as well as the Mississippi Religious Freedom Act, which essentially makes it strict scrutiny anytime you're doing anything to impede, religious freedom. And so the case, this may be, I imagine, is going to be a continuing theme throughout several of the presentations today. One of the challenges of dealing with COVID-19 litigation is that everything is so fast-moving, everything is so temporary, that you often are kind of litigating in the court of public opinion, but don't really get any relief from the court before the entire issue is moot. So in this situation, our case and our sister case, I guess I'll call it, with the other church in Greenville, captured national attention really quickly. It was, on national media outlets like Fox News and CNN and all of that. And the DOJ wound up intervening in one of the cases and was about to intervene in the second case. Our governor was very outspoken about the issue, saying that the drive-in church ban should not be in place. And so essentially the day that we filed our lawsuit, later on that same afternoon, the mayor held a press conference and announced that he was essentially backing down and was going to pass a new executive order that very clearly did allow drive-in church services. And of course, a few days later, he did pass that new executive order. So the case was really mooted very quickly. But, in the court of public opinion, we felt like it was a good win to be able to stand up to the mayor and have really everybody on our side with it. So the next case I'll discuss very briefly is this one is really even more interesting than the first, I think. So on April 25th, 2020, well into the pandemic, the mayor of Jackson, and so Jackson is the capital city of Mississippi, and our mayor is Mayor Lumumba, and he's a self-described radical. And so he issued an executive order that banned the open carry of firearms in the city of Jackson. What was interesting about it is that he did not even really attempt to link that executive order to the pandemic or to coronavirus. So if you watched his announcement of the executive order on a YouTube video and other places where he announced it, he really didn't even try there to link it at all. He just talked about, how guns are bad, basically. And then in the actual executive order itself, if you pulled up the PDF of it and read it, there was a, very kind of weak attempt to at least link the executive order in some way. But it like I said, it was very weak. It just basically said that the virus causes people to be scared, which causes them to amass guns and ammunition, which increases shootings. So, of course, there was no evidence that, shootings had been increased in the city of Jackson at all during the pandemic, or that the shootings that had occurred were linked to the open carry of firearms as opposed to, any other form of firearm carry or robbery or something like that. So the problem for the mayor was that, number one, the Mississippi Constitution, the text of our version of the Second Amendment, seems pretty clear if you read it. There's really no court cases on it because it's never needed to be litigated. But the text itself is very clear that open carry cannot be prohibited or even regulated. Only the concealed carry of weapons can. Secondly, Mississippi statutes explicitly protect the open carry of firearms. And third of all, the mayor's emergency powers that he was citing, the statute that gave him the authority to issue an executive order, did not authorize him to override state statutes. It clearly didn't authorize him to override the Mississippi Constitution either. And so, obviously there were a lot of problems here. So we filed a lawsuit on behalf of a state legislator, a state representative who was in the capital city very often and carried a firearm when he was, sometimes open carry. And what was interesting is that after we filed the lawsuit, the city council for the city of Jackson, as many cities, the form of government is a mayor and a city council that work together. And so the city council, I've never seen anything like this. They threw the mayor under the bus. They hired their own independent attorney. They legally took the position, both in their answer to the complaint, in a motion where they agreed with the Attorney General of Mississippi, intervened in our case and filed an amicus brief. They filed a motion in support of the Attorney General's amicus brief. They held a press conference where they said they agreed with our position. It was insane. I've never seen the city government, an arm of the city government taking the position that the government is in the wrong. One thing that we think led to that was that we've been litigating with the city of Jackson on a separate case and had just won a pretty hefty attorney's fee award against them. So the city council wasn't glad that the mayor had unilaterally acted in this way that exposed them again to another lawsuit from our group. And I think they were basically trying to undermine his position and make it very hard for him to continue to litigate it or to try to keep his executive order in place. So very similar to the last case, the mayor, his order was only set to last for 4 days when he issued it. He tied it to another executive order he had that was kind of an emergency declaration that was set to expire in 4 days, and he tied this to that one and said this will expire when the declaration expires. But he had been holding out the threat that he might, I would call it a threat, that he might extend both of those executive orders, and he wasn't sure if he would or not, but he might extend them. So when the day arrived, 4 days after he instituted the ban, and 3 days after we sued him for it, he let the ban expire, and so it's no longer the law. One kind of lesson we've learned here that may be good for other groups that try to litigate COVID issues, we've argued that because the pandemic is still ongoing, and given the very short duration of the mayor's order, it seemed like a publicity stunt that he could do again anytime, that the issue was capable of repetition and evading judicial review, and therefore the case is not moot. And we're in, basically in settlement discussions right now with the mayor and the city council, and it looks like in the very near future we will be entering a proposed consent decree to the court to enter, which will basically ban the city of Jackson from ever doing this again. So we'll be glad that we're hopefully at least able to walk away with some relief from the court, even if it was agreed to by the parties in order to end the litigation. So, Colleen, that's both of my cases, and I'll stand by for the next group.
All right. Thanks so much, Aaron. And looks like we've got Rick on the line. Rick Essenberg is the founder, president, and general counsel at Wisconsin Institute for Law and Liberty. They are always very busy, but they have been especially busy doing some really important litigation recently due to COVID, and I'll let Rick tell you all about that.
Okay, I think I'd like to talk about 3 cases. One we don't need to spend a lot of time on. It's very similar to the situation that Aaron faced. Right before Easter weekend, there were a number of local units of government in the state of Wisconsin that were taking the position that the statewide stay-at-home order banned drive-in church services. It was our view that the text of the order did not, in fact, ban drive-in church services, and if it could be construed to ban drive-in church services, it would be unconstitutional, particularly given the fact that Wisconsin state constitution does not follow Employment Division versus Smith. Under Smith, of course, neutral laws of general applicability do not violate the Free Exercise Clause. They don't get heightened scrutiny. Wisconsin doesn't follow that. In Wisconsin, a burden on religious practice is subject to strict scrutiny. We put out a statement actually an open letter we sent a letter to the governor and then publicized it, basically saying, look, Governor Evers, we don't think your order prohibits these drive-in church services, and if it were to construe to prohibit them, it would be unconstitutional. The governor, to his credit, responded and said, I don't believe that my order does prohibit drive-in church services, and at that point, it became a non-issue. And to my knowledge, no local unit of government attempted to interfere with any drive-in church service, and they went ahead as scheduled for the Easter weekend and beyond. The second case is really not so much a shutdown order, but an abuse that sort of grew out of hysteria surrounding the pandemic. Our client is a high school student who had been on a band trip to Florida in the first part of March. She came back from Florida. She felt ill. She was eventually taken to the local hospital where the doctors told her that she did not qualify at that time for testing. That was when testing availability was very, very limited, but that they were fairly certain that she was infected with the virus. She was sent home. She did not get better. Her parents then took her to the University of Wisconsin hospitals in Madison. She was tested there, but the doctors told her that they thought that, and she came out negative, but the doctors told her that they believed that she nevertheless was infected with the COVID virus. They said they believed that she was beyond the window in which the test that they were using would register as positive. None of that is directly relevant. What is relevant is that she then went on Instagram. She informed her friends what was happening to her. She informed her friends that the doctors had informed her that she was infected with the COVID virus, but she was getting better and that they shouldn't worry about her. In response to that, the local sheriff sent a deputy to her home. The deputy confronted her and told her that she must take down the Instagram post immediately, or that she and her parents would be taken that would be charged with disorderly conduct and taken to jail. When we heard about this, we wrote to the local sheriff. We said, look, you can't do that. We want you to confirm that you're not going to take action against our client and her parents. She did take the Instagram poem down, but she also wants to know that you won't do this again, that her rights of free speech will not be interfered with. For reasons that are still unclear to me, the sheriff declined to do that, and so we filed litigation seeking a declaration and injunction that this not be permitted. The matter has been briefed. It's pending, and it may be resolved, sort of litigation. But this was not something that was compelled by a safer at home order, but was something that I think grew out of sort of a sense that at times like this, that the normal rules don't apply. The third case I want to talk about, I think, has a broader significance. Last week, Wisconsin became the first state to move off of lockdown by litigation. But the case was not a claim of individual constitutional rights as we normally would expect it to be, but rather it was a case that focused on structural limits on the power of government. What happened in Wisconsin is our state law says that the governor can declare a public health emergency for 60 days. That public health emergency can be rescinded at any time by the joint resolution of the legislature. It can be, it ends after the 60 days and can be extended only for another 60 days but that would also require a joint resolution of the legislature. Our public health emergency was set to expire on May 12th. Our governor issued his initial stay-at-home order in the latter part of March. As it was nearing expiration, he had a choice to make. He could either go to the legislature and get authority to continue the order. That would have required him to compromise as to its terms, or he could choose to go it alone. He chose to go it alone, claiming that he could rely on a different statutory provision that gave broad authority to the Department of Health Services to take steps to control infectious disease. In essence, he said that this was a back door that would allow him to instruct a single cabinet member to do what he could not do, and that is lock down the state indefinitely without legislative oversight. We put out a paper following his extension of the order, or following his direction to the acting secretary of the Department of Health Services to extend the order, indicating that this was an anomalous result, that we did not think it was a correct reading of the statute, and that if it were a correct reading of the statute, it would be unconstitutional violation of the separation of powers, because it would, in a sense, it would in essence give the power of legislation to a single legislative. We didn't file the lawsuit. We thought about doing it, but the state legislature came to the same conclusion. They said they would do it, and they did. And they did not directly attack the constitutionality of the statute. They said, rather, that it had to be subjected to a narrow interpretation, and argued that the existing or the extended safer at home order was too broad, and that there was not sufficient authorization in state law to permit the Department of Health Services to do things like order people to stay home, or to not engage in essential travel, or to close any business that was deemed to be non-essential, and that whatever restrictions state law did support had to be adopted by rulemaking. And rulemaking, of course, would require public notice and comment. It would involve legislative oversight, as under our State Administrative Procedure Act, a joint committee of the legislature can suspend a rule. It does provide for emergency rulemaking, so you can act quickly, but they said that this rulemaking, the legislature argued that this rulemaking had to be used in order to continue the safer at home order beyond that period of time when it could be based upon the governor's public emergency powers. This was important because although the extended safer at home order was set to expire on May 26th, it was followed up by something called the Badger Bounce Back Plan, which set forth a number of gating criteria and core responsibilities for limiting the statewide, or for lifting the statewide restriction. And I think it's safe to say that they were very indefinite, very discretionary, and very unlikely to lead to any substantial loosening anytime soon. The court, this case was an original action filed in the Wisconsin Supreme Court. So it went from basically from filing to oral argument before the court in a little less than 2 weeks. It went from filing to decision in about 3 weeks. The court concluded, agreed with the legislature that rulemaking had to be employed. It agreed with the legislature that the safer at home order had to be narrower than in fact it was, that it could not order people to remain in their homes. It could not forbid all so-called non-essential travel. It could not close all so-called non-essential businesses. What we were able to do as a supporting entity in the case is provide support for the legislature's argument that one of the reasons that the statute had to be read narrowly was the doctrine of constitutional doubt. Right? This idea that if a reading of a statute will present a constitutional problem, that the statute should be read narrowly to avoid it. The legislature did not develop the constitutional problem with the statute. We, in our amicus brief that was filed on behalf of a small business organization and a number of small businesses, did develop that argument. And we essentially said that although the non-delegation doctrine has not been robustly enforced by federal courts, there is indication that the U.S. Supreme Court is re-examining that hesitance, and that there are substantial reasons to suspect that our separation of powers requires substantive direction on the part of the legislature to an administrative agency when it is empowering that agency to make rules. We also relied on some cases that had been developed by the Wisconsin Supreme Court under our Constitution, which said that that if the legislature is to empower an agency to make rules, there must be procedural protections. Procedural protections could be a limited duration of the effectiveness of a rule, so that perhaps it's okay to let the governor declare a public health emergency because that public health emergency is time barred. It could be the requirement of rulemaking because that would provide an opportunity for public input and legislative oversight. But in this case, there was neither substantive direction because the most you could say is the law said to the agency, do whatever it takes to control infectious disease. And there was no procedural protection at all unless you imposed this rulemaking requirement. The court ruled last Wednesday. It was my expectation, quite frankly, that the Republican Legislative Caucus would have its own plan for a transitional regime that would bridge moving from lockdown to back to normal. To date, the legislature has not done that. They have not proposed a plan. I think they cannot agree on one. It was my expectation that the governor would promulgate a new rule that would incorporate as much of his earlier order as he could. He initially issued a scope statement, which is how you start rulemaking in Wisconsin. But yesterday at noon, he withdrew the scope statement, saying that he didn't think the legislature would approve anything that he did, and so therefore he wasn't going to go forward to it, and there's now no statewide restriction at all in the state of Wisconsin. In response to that, some local counties have issued their own orders to the extent that they attempt to reprise the statewide lockdown, stay-at-home order is probably going to run into the same problems with respect to scope as the statewide order did, but that round of litigation has not happened yet, and we don't know for sure how it's going to come out. So that's essentially where we are in Wisconsin.
All right. Well, thanks so much, Rick. We'll move right on to Sam McRoberts, General Counsel and Litigation Director at the Kansas Justice Institute.
Thank you. So I'm Sam McRoberts. I do run the Kansas Justice Institute, and we have an office in Overland Park, Kansas, and in Wichita, Kansas. So in about middle March to the latter part of March, when COVID started flaring up and started appearing in a few of the Kansas counties, local health officers started issuing local health guidelines. And according to state statute, local health officers are empowered to take all known measures to prevent the spread of contagious diseases. And there's another statute that allows local health officers to prohibit public gatherings. So at the very beginning of the pandemic in Kansas, local health officers started issuing localized health orders. And for the most part, they were fairly reasonable and kind of just saying, make sure you're socially distancing, and that's that. As a few more cases started popping up, then the local health officers started becoming more restrictive, and then we started seeing things pop up like emergency management departments saying, well, things like picketing or car parades or any type of speech is not considered an essential activity. So we started getting involved in those cases very, very quickly. And then all of a sudden, Governor Kelly started issuing statewide orders regarding stay-at-home and social distancing. When she did that, it essentially, the way her executive orders were written, took power away from the local health officers. And again, in the beginning, her executive orders, for the most part, were fairly reasonable and were not going overboard, and people generally didn't have a problem with them. I guess people had problems with them, but there wasn't anything specifically that could be done. There were no constitutional issues really at the very beginning. Then all of a sudden, she switched her executive orders to re-empower, so to speak, local health officers, and said, well, if you want to be more restrictive on a countywide basis than on the state basis, you're free to do that. So go ahead and issue your local health orders. Once she said that, then of course local health officers started issuing very broad health orders, and that brings us to our first case, which is Jackie Taylor and Linda Jo Hissel versus Jay Allen, who is the local health officer in Lynn County, Kansas. And what Dr. Allen did was he issued a local health order that required businesses to compile lists of patrons. And the order was so broad, it applied to law firms and doctors' offices and banks and insurance firms. And anytime a person would have to go into the business, there would need to be a list of the patron and people in the party, including the time a person gets there, the time the person leaves. And the local health officer order did not expire. There was no end date. What was particularly problematic was the health officer wrote in the order that any of these documents must be made available upon demand. And there was no sort of process by which a business or a person could object to the turning over of these records, and there was no warrant requirement. So we represented Jackie Taylor, who runs a newspaper in Lynn County, Kansas, and Linda Jo Hissel, who runs Nana Joe's Cafe in Lynn County, Kansas. And on the 10th, we filed a case in Federal District Court of Kansas based primarily on the Fourth Amendment and the pre-compliance review case of City of Los Angeles v. Patel. And our main argument was you must provide a pre-compliance review process. So if a business owner like Linda Jo objects, then the local health officer has to go get a search warrant or some other type of legal process. And we thought, we were pretty confident that the local health officer would just rewrite the health order, but he did not do that. And essentially dug in his heels and said, no, we believe that we're allowed to do this. And so let's duke it out in court. So we briefed it up for a temporary restraining order and had a hearing on Friday. And the temporary restraining order hearing lasted about, I would say, an hour and 45 minutes, maybe 2 hours. And the court really did a great job of getting into, does the health officer have the ability to issue these orders under the all known measures statute, or is this really under the prohibition against public gatherings? And the defense counsel didn't have a very good answer of how or why the health officer could issue this type of health order without any sort of pre-compliance review process. And during arguments, defense counsel essentially conceded that there wasn't a statutory mechanism to enforce the list requirements. And incredibly, the response was, well, we meant for this to be voluntary the entire time. And we meant for businesses to be able to object. And of course, we were going to get a warrant. The court, to her credit, cross-examined for the most part the defense attorney. And one of our arguments with respect to Jackie Taylor, she was a citizen. She wasn't required under the health order to keep the list, but we were making the argument that her Fourth Amendment privacy rights were being violated by essentially being unable to escape from this entire warrantless regime. So if she goes to the bank, she's going to be listed. If she goes to her law firm, she's going to be listed. And we basically took the position that Carpenter applies and Jones applies, and that she has a different privacy interest than our client, Linda Jo. The court really picked up on that argument and talked in depth about Carpenter and the right to privacy, and that if you are out in public, it doesn't mean you're losing all of your Fourth Amendment protections. And so we had this hearing, like I said, on Friday. And then, as Aaron mentioned earlier, on Sunday evening, the local health officer issued a brand new health order that said people can object to turning over any of these sort of lists or documents. And once they make that objection, then the local health officer has to get either a warrant or legal process to get those documents. And it became clear from, at least my perspective, from the way they wrote the health order, that they essentially conceded that there's no statutory enforcement of the list keeping requirement. So once they issued the new health order, then Monday we sat down with the clients, had a conversation with them. They also put an end date on the local health order. So we sat down with the clients, and then we talked about mootness, and we did a voluntary dismissal of that case yesterday afternoon. So the court didn't issue a ruling, and so that is our Fourth Amendment case. Another case that we did, this was more litigation by letterhead. So a lot of the local health officers were banning car parades, which I'd never really heard of until they started banning them. So in some of the small communities where high schoolers they couldn't have graduation or they couldn't have proms, what they would do is they would put signs on the side of their car and drive around neighborhoods and wave to their friends who would be on their front porch, or they would drive down small communities like on Main Street, just good old fashioned, I guess this is what used to happen back in the day. And so local health officers said, for really some unknown reason, that you cannot do a car parade. And so we got involved in a couple of cities who were banning car parades, wrote letters to mayors, and they quickly said, okay, well, we're not going to ban car parades anymore. And then we got involved on behalf of Derek Stowers in Osage County, Kansas, where the local health officer banned an Easter car parade. And what's very interesting is in a lot of the small counties, they're not issuing health orders like you would think. What they're doing is going on Facebook through the county Facebook page and saying, this is what we're doing. And so they issued basically a statement on Facebook saying there aren't going to be any car parades. This is banned. So we sent a letter to the health department officer, and to their credit, they very quickly reissued a statement saying we're not banning car parades. We understand essentially you've got the right to free speech, free expression. I was making a right to travel claim, and that got resolved very quickly, probably in a day and a half or 2 days. And since that, it's my impression that all the other counties have backed off of their car parade bans. The other litigation by letterhead, we've been doing during the pandemic is anytime the governor issued an executive order that perhaps we liked, we would send a letter saying this is the right decision. And anytime we saw an executive order we didn't think was appropriate, we would issue a letter saying the same thing. And that leads us to the religious freedom issue. So at the very beginning, Governor Kelly did a good job of exempting the churches from any sort of mass gathering ban. And then she backpedaled and started saying, and made very explicit indications that churches couldn't be meeting with more than 10 people, but at the same time allowing shopping malls to be open or other places like bars and restaurants. And so we sent a letter saying this is not going to pass muster under the Kansas Religious Freedom Restoration Act and the Kansas Constitution, which is worded differently than the United States Constitution, and courts have interpreted that to provide more religious freedom. So eventually a lawsuit was filed, not on behalf, or Kansas Justice didn't file it, but then we filed an amicus, and the federal district court in Kansas down in Wichita said issued a temporary restraining order saying the governor's executive order was unconstitutional under the First Amendment. So those are the three cases specifically that we've been working on.
All right. Thanks so much, Sam. We'll move on to Tim Sandifer, Vice President for Litigation at the Goldwater Institute, to talk about a couple of election-related cases that we got involved in Arizona.
Thanks. Boy, you guys sound like you're doing some really exciting and interesting cases, and I keep reading about new and more complicated legal issues coming up all the time. The ones that we were dealing with here in Arizona, actually it's two cases that are very closely related, one federal and one state, and they involve political campaigns to put initiatives on the election ballot coming for this coming election, and of course you have to gather signatures for that. And the question was, what do you do in light of the governor's orders to stay home, since it makes it a lot harder to gather signatures for that? Well, in Arizona, you can gather online signatures for candidates who are running for office, but the statute does not allow online signatures for putting initiatives on the ballot. And so these groups filed lawsuits, one in the state Supreme Court and one in the federal district court, arguing that that difference in treatment violated various provisions of the Constitution. The more bizarre, I thought, argument was that it violates freedom of speech, but there was also, it violates equal protection and so forth and so on. And one of the arguments that we made in our amicus brief in this case, in both of these cases, was that, of course, it doesn't violate freedom of speech because everybody is still as free to speak as they were to begin with, and you have no right to, under the First Amendment or under the free speech clause of the state constitution, to place anything on the ballot. You have the right to vote for something that is on the ballot, but you don't have a constitutional right to put something on the ballot that doesn't have the required number of signatures. And what's even more complicated is that the Arizona Constitution's language pretty much requires in-person pen and ink signatures for ballot initiatives. Arizona has had an initiative process since it was created in 1910 and 1912 with the state constitution being written by progressives who believe strongly in the initiative process. And the language that they used in the state constitution says, it requires that a person sign, and then that the person who's circulating the petition then sign an affidavit of his own to the effect that the signer signed in his presence. And so that plainly contemplates a two-person operation, and there's really no adequate substitute for that in the online world, or at least there isn't one that has been approved of by Arizonans. These lawsuits are trying to get the courts to adopt it by fiat and simply say, we will, just require this, even though it has never been required by the legislature. There is actually, interestingly enough, a Maryland case that sort of allowed this on the grounds that nothing in the state constitution prohibited a signer and a petition circulator from being the same person, that you could effectively sign an affidavit verifying the legitimacy of your own signature. There it's distinguishable for a number of reasons. For one thing, that the state legislature in Maryland had approved that process, and it has nothing like that has been approved in Arizona. But in any event, the remedy that was being sought in these two cases was essentially contrary to the Arizona Constitution, that plainly requires in-person signatures. And maybe we think that's obsolete or outdated or whatever, but if so, then the proper step is to amend the Constitution. And we're particularly concerned with the idea of tampering with the election rules in a time of crisis. I think Rick, our friends in Wisconsin, can certainly sympathize with this concern, that messing with the way elections are run because of an emergency, that's a very dangerous precedent to set. When does the emergency go away? What happens the next time there's an emergency that might be less severe, but still it's used as an excuse for tinkering with the election rules yet again? And we're talking about, a nation which held a presidential election in the middle of a civil war in 1864, and in Arizona, we held our statewide gubernatorial election in November of 1918 in the midst of the Spanish flu epidemic. So there's no precedent for just changing the election rules by judicial fiat in the midst of an emergency. The Arizona Supreme Court has rejected the petition, and they have not issued an opinion yet. However, they're still working on that, and we don't really know when they'll issue it. It could be a long time. The federal case, the district court threw the case out, and that case was an appeal to the Ninth Circuit. And the logistics of it were that the plaintiffs wanted to get an injunction from the Court of Appeals pending the appeal. That injunction would require that the state allow electronic signatures for ballot initiatives, which means that would be essentially the whole game. So that went to the motions panel, and we filed a brief there as well, urging the court not to grant the relief requested. And the court did deny that request, and then yesterday evening, I believe, the plaintiffs withdrew their appeal, and so that case is now concluded. So those have been the election issues that we've been working on here. We haven't really been involved directly in Arizona in any kind of a statewide litigation yet regarding the governor's orders, because I'm glad to say, at least our view is that for the most part, the Arizona state government has acted pretty responsibly. But we did issue a letter just yesterday to a county, Pima County, that's Tucson, to Pima County, which has adopted a set of rules to govern the reopening of businesses in the county that conflict with the governor's order. The governor's most recent order says businesses should come up with rules of how they're going to operate safely, consistent with the guidance from state and federal agencies. And Pima County didn't want to wait around for mere capitalists to write their own rules, and so they adopted their own very carefully designed rules that in many cases don't make any sense at all, and imposed those on businesses. And so the Attorney General has also already begun processes against the county, and we sent a note to the county saying, you really need to repeal this proclamation. The county's meeting today to discuss that. So it's another example of something that we've been talking about a lot on this call, which is the need to police what state governments are doing. City governments are doing, local governments that are, they're feeling the pressure to do something, anything, even when that might conflict with state law. So that's what's going on, Colleen. Let's go on to the next our next step.
Sounds great. Thanks so much, Tim. And last but certainly not least, we have Howard Dorman and Mark Victor at the Attorneys for Freedom Law Firm, who, as I mentioned before, are AFM partners with us. And they just have taken on the most recent case that we'll talk about today, where the city of Fountain Hills in Arizona used the governor's order to abuse a local business owner. And so Howard and Mark, I'll let you take it away.
Sure. Yeah. Thank you, everyone, for having us. By the way, this is a real pleasure. And Mark and I have been sitting here listening to the cases that you've all been talking about, and we're blown away by most all of them and the issues going on. It's pretty interesting stuff, and kind of shocking to think that this out of nowhere pandemic created these problems around the entire country. But nonetheless, at least we're all here to fight them. Our case involves a lady by the name of Marita, and her last name is oddly spelled because she's an immigrant, but it is pronounced Idritsa. And Marita is originally from Albania. So she moved to the United States over 20 years ago. She left Albania, which is at that time was a country that was communist run. So she's leaving an oppressive area to come to the area of freedom, and land of freedom. And 20 years later, it's almost like she's reliving her days back in Albania. Marita's restaurant is a pizza restaurant. It's located in Fountain Hills, which is a small town just outside of Phoenix. It's relatively known for kind of an older crowd. A lot of retirees live there, and it's a very tight-knit community. So it's political in the sense of if you get on somebody's bad side, you're on everybody's bad side. Fortunately for Marita, she's got a nice mix. She's got about half and half. Some people are on her side, some people aren't. Unfortunately, the ones who aren't involve a lot of law enforcement connections. During the beginning of April, this whole thing started April 2nd and ended roughly April 7th. April 2nd, there's some calls that go around between the local law enforcement, which is the contracted county sheriff's office, because the city doesn't have their own. So there's internal investigations and conversations amongst the contracted law enforcement, as well as some city officials, the current mayor of the town, and they're basically saying that Marita is violating the governor's orders about how food service can be handled. In Arizona, Governor Ducey ordered all restaurants could not serve anyone inside. There was no sit-down eating allowed. It was only carry-out. So Marita sets up essentially a walk-up area to her restaurant. She blocks off the front doors with this walk-up area, and she serves people their food. Whatever they order, she gives them. They're in bags, and they walk away and they go wherever they choose to eat. Herein lies the problem. Some of her seats are outdoors, and for the most part, she's gathered them up. She's either stacked the chairs and the tables so no one can sit at them, or there is other businesses who have tables, and one of her tables is a large picnic table that's solid steel, if you will. Very hard to move, and it's also around the back side of her, or the far long side of her business. Over the course of these 5 days, the police show up, and they say, we have no intent to cite you. We're not trying to cite you. We just need you to be in compliance. We're getting a lot of complaints. Meanwhile, there are hundreds of people in a park next door, literally like within walking distance from this restaurant, who are eating all sorts of different kinds of meals. Nothing specifically from her restaurant, but certainly nothing to say they're all from her restaurant, right? And the police don't cite any of those people. They don't tell any of those people they have to leave the park. Nothing like that at all. So on the day of April 7th, the police show up again. This is the fourth time over that 5-day period that the police have shown up. And coincidentally, when they arrive, there are 2 tables being used. One is the one that belongs to the adjacent business, which is a mortgage company. And the other is this large steel heavy table along the far side of Marita's business. At the table that's owned by the other company, there's a gentleman drinking a beer, and the beer is in a paper bag. And looks like he and his wife, or at least he and his companion, are waiting for their food. And the beer was given by our client. It's placed in a brown paper bag and sealed. Again, what someone does with it when they leave is up to them. Certainly that person didn't get cited, but the officer essentially told him he couldn't do that and he needed to stop, which the gentleman agreed to do. The officer then goes into the adjacent business and asks them to move their table inside so that people can't sit at it, which they agree to do as well. Then the other table, that heavy one, is being used by a gentleman and, again, his wife or companion, and he's eating his meal. He ordered a calzone, and it was unclear what his wife was eating, but they're both sitting there across from each other, enjoying their meal, and the officer, again, says, you guys can't do that. You need to pack it up and leave, which they do. A little bit of resistance, but in the end, they end up picking up their stuff and going on. The officers then confront Marita and say, you can't have people eating food outside your business. We've told you about this. And her position essentially is, what do you want me to do? I can't control what people do. I can't control where they take their food. My interior restaurant is closed off. No one can sit here. There's no seating available. It's all been blocked off with the exception of one booth, which the police have photographed. And my client's position, from what I understand, is it was for employees when they were taking a break. Certainly no one was invited into the restaurant to eat there. And my client gets a little abrasive with them. I think she's kind of frustrated, and understandably so, because essentially, as it states in the agenda, the police are harassing her at this point. They're also expecting her to police her own business and the exterior of her business, when all she's trying to do is continue to make a living and serve people their food. So she's cited with which Title 26, which Title 26 is Military Affairs and Emergency Management. And the specific statute is 26-317, which is titled Violation. And it simply says, any person who violates any provision of this chapter or who knowingly fails or refuses to obey any lawful order or regulation issued as provided shall be guilty of a Class 1 misdemeanor. In Arizona, Class 1 misdemeanors are the most severe. They're the highest level. They carry with it up to 6 months in jail, up to 3 years of probation, and up to $2,500 in fines and fees. The other sentence that's part of this statute reads, and this is the most interesting one that we're going to have kind of driven to the level of exploration, is this provision does not apply to the refusal of any private organization or member thereof to participate in a local emergency or state emergency as defined by this chapter. So certainly there is a bit of confusion on, was she even cited correctly? And if so, well, what about that last sentence that basically says you're a private citizen, a private business owner, you can't be cited for violating the statute. On top of it, there are a handful of other constitutional issues that we're exploring. And I'll actually pass it over to Mark, because Mark is much more well-versed in this than I am. So go ahead, Mark.
Are we almost out of time? Do we have any time to go through this? If we do, I'll try to make it fast. Someone can give me the hook at any time, I suppose. But in any event, I think the main problem here, besides the issue Howie pointed out, is the separation of powers. I'm also very, very concerned about an issue that we just haven't made any progress on, which is 10th Amendment. The 10th Amendment's great when people are complaining about federal government doing crazy things, but when the state government is doing crazy things, we're stuck with this notion of regulating health, welfare, safety, and morals. I don't know where this comes from. It's not consistent with any idea of natural rights or delegation of authority to state government. So I think it's time that we litigate this stuff. And then, of course, there are a whole host of other issues, taking clause questions, maybe even contracts clause questions, dare I say privileges and immunities, or maybe even this lost amendment called the 9th Amendment. So I like raising these kinds of things. We're interested in raising these issues. I think it's a great opportunity. And I just want to conclude by really saying kudos to all the lawyers on this call. If we don't push back on this craziness, nobody else will. And so we're I think, all members of the most important profession. This is the time we need to stand up, and I'm just honored to be part of this group. So thank you very much. And I'm sorry we went a little over on our time.
No problem. Thanks so much, Mark and Howard. Yeah, and this is Colleen Lindgren. I'll just jump on for Goldwater. And we've had a lot of folks reaching out to us to see how they can get involved. And whether it's COVID-related things or in the future, please always feel free to give me a shout. I'm always happy to chat about ideas you have for cases or things that are going on in your state that you think should be looked into. That is one of my major roles at the Goldwater Institute, and we want to not only be effective in Arizona, but across the country in helping fill the gaps on making sure important cases get litigated. So even if it's just an idea or you have a question or, feel free to always reach out. I'm happy to be a resource or connect you with other groups that are working on issues that you're interested in as well. If nobody has anything further, I know we're a little over our time, so I will just say thank you to our speakers. Thank you to all of our attendees. I hope you found this helpful and interesting. And if you have any follow-up questions or think of things later, please feel free to shoot me an email. I can either answer it myself or get you connected with the right person. And thanks so much for everybody's time. Have a wonderful day.